So we now come to the first essential requisite of contract, which is consent. Okay. Again, we learned from Article 1318. Article 1318 provides for the essential requisites of contracts, which is first the consent of the contracting parties, and then you have the object certain and the cause of the obligation. We learn from the provisions of the contract of sale that there is a perfection of a contract when there is a meeting of the minds upon the thing, which is the object of a contract, and upon the price or the consideration or the cost of a contract. Um, this provision from the provisions of the contract of sale particularly describe um, or define when there is when perfection of a contract occurs, no, and it happens at the moment of the meeting of the minds upon the thing or upon the object of the contract and upon the price or upon the consideration. If it is a contract of sale, then it is for the price. But for other contracts, there could be other consideration. No, it's not only upon the payment of the price. And for the meeting of the minds, it requires legal capacity. And secondly, that consent must be freely given. And third, there must be acceptance of the object and the cause of the contract. And also, we learn that, and from that moment, that there is a meeting of the mind upon the thing and upon the cause or consideration of a contract. It is at that moment that the parties may reciprocally demand performance. Because remember, as we have discussed on the first part of the lecture, one, um, anong tawag doon? One characteristic of contract is the mutuality of the contract, and that they have to be complied with in good faith. And from that moment that there is a perfection of the contract, there is a meeting of the mind with respect to the object and the cause of the contract, then the parties could now reciprocally demand for the performance, no, of their respective obligation arising from the contract. And this reciprocity or demandability of performance, no, they could be found from its basis could be from Article 1159. Again, you get back to the provisions of obligations, that obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. And also with respect to the to to the provision of contracts on Article 1315, that from the moment that there is a perfection of a contract, no, the parties are bound for the fulfillment what has been stipulated, as well as to the consequences, no, in accordance with the nature, and they must to the nature of the contract and in keeping with good faith, usage, and law. So, yung understanding natin is there is a perfection of contract when there is a concurrence of the three essential requisites of contract. And that is consent, you have the object, and you have the uh, cost or consideration. And essentially, a contract is perfected at the time, at the moment, there is a meeting of the minds. And that meeting of the minds presupposes concurrence, mutual concurrence, or acceptance with respect to the object and to the cost or consideration of the contract. And it presupposes that when parties come into agreement, they must have legal capacity. Their consent must be freely given, and there must be an acceptance of the object and the cost of the contract. So, tatandaan nyo yon. Okay? And from that moment that there is a meeting of the mind, no, where it gives rise to the perfection of the contract, it is at that moment that the parties may reciprocally demand performance. And they are also bound on the fulfillment of their respective obligation under the contract that they have entered into. And they have to comply the terms and their condition and the conditions entered into in good faith and in accordance with law and usage. Okay, remember that. Remember that. Okay. So, what have we understand so far? First is that contracts are perfected by mere consent. Ibig sabihin, consent, there is a mutual agreement um, with respect to the object and to the consideration of the contract. No? And however, not all contracts are perfected by mere consent. There are contracts that are perfected by the delivery of the thing, or they are perfected with the execution of an authorized deed for their that is a requirement for their validity or for their perfection. But generally, contracts are perfected by mere consent. And to be able to give consent, one must have legal capacity, and one that consent must be freely given. And that consent is with respect to the acceptance of the object and to the cost or consideration of the contract. Okay. So what is legal capacity? Yung legal capacity is it is not defined in the provisions and obligations and contracts, neither in the provisions, no, pertaining to sales or credit transactions. But legal capacity is defined in Book 1 and persons. No? It's legal or juridical capacity. And what is this legal capacity? No? Juridical capacity is the fitness to be the subject of legal relations and is inherent in every natural person, and it is lost through death. Capacity to act, no, is the power to do acts with legal effect. Ibig sabihin, when a person has legal capacity or juridical capacity, his action will have legal implications. Kaya nga, remember our definition of obligations. It's a juridical necessity to give, to do or not to do. It's a juridical necessity because it presupposes that the person who is given an obligation, no, has a legal capacity, and so his acts would have a legal bind. He could legally, there is a binding effect as to the consent that he would give, and there is a legal effect of his action or whatever contract that stipulation that he may he may enter into, no? Um, and that legal effect would give rise to certain rights and claims, no, with respect to the other party to enforce yung rights nila before courts of competent jurisdiction. Kasi otherwise, kung walang legal capacity, uh, he could not bind himself, or his action would not have any binding effect, no, to for him to enter into contracts that would be enforceable before the court of law. So the assumption is natural person, ibig sabihin katulad natin that who are born, naturally born, no, would have juridical capacity or would have legal capacity, and our action would be uh, would have legal effect. So when we enter into a contract, um, it would create rights and certain claims, no, and they would be enforceable before the court of law. And in case there is a breach of contract or a breach of that obligation, then we would be liable for damages. Article 38 of the Civil Code, the NCC provides that minority, insanity, or imbecility, uh, yung imbecile, yung understanding natin doon ay kasi yung minority, alam natin na 18 years old below, no? Kasi yung age of majority natin is 18 years old. Yung insanity ay kabaliwan, no? Pero yung imbecility, yung ang ang age niya saka yung mental faculty niya, they do not coincide. Ibig sabihin yung mental faculty niya ay below yung kanyang expected na age. So, kung halimbawa, one is 25 years old pero yung mental faculty niya ay that of 5 years old, then he could be considered an imbecile, no? Or the state of being deaf mute, no? Kaya lang, yung deaf mute dito, that is condition na deaf mute who could not read and write, no? Then prodigality, civil interdiction, ibig sabihin, merong restriction yung kanyang act because of a law that inhibits it. And so these are restrictions of legal capacity. It could be minority, insanity, or imbecility, the state of being deaf mute, prodigality, civil interdiction. What what ano yung reason behind na these are restrictions? It's because kung papansin ninyo, etong those persons afflicted with minority, insanity, or imbecility, the state of being deaf mute, prodigality, these are persons who could not really give consent. And so it affects their legal capacity to enter into a contract freely or to abide by their obligations freely. Again, Article 39, it's just an expansion, no, of the restrictions that are provided for in Article 38. As to restrictions ng legal capacity, again, it provides that the following circumstances, no, they modify or limit capacity to act. That is, it pertains to legal capacity. Age, insanity, imbecility, the state of being deaf mute, penalty, prodigality, even family relations, alienates, absence, insolvency, and trusteeship. So, yung provisions, if you have read the provisions nung sa contracts with respect to persons who could not enter into contract, which we would also later on discuss, these are not exclusive. There could be other instances that would limit the juridical capacity of the person, and so it would limit their capacity to give consent in a contract. And they could be age, insanity, imbecility, the state of being deaf, mute, penalty, prodigality, family relations, could be trusteeship, no? Yun. And as you have read, no, sa article, so we now relate to Article 1327. It provides here categorically that the following persons cannot give consent to a contract. And this is in relation to what we have discussed, no? Unemancipated minors and insane or demented person and deaf mutes who do not know how to write, um, who don't know how to write. Uh, so yun, it's just yung sa Article 1327, no? It's just an particularizing the provisions of Article 38 and 39 under Book 1 and person with respect to legal capacity. So, insane, demented person. So, yung demented person, it's like yung imbecile din. Kulang-kulang. Yung insane is baliw. Pero pag yung demented person, remember the word dementia, parang kulang yung kanyang mental faculty. Nakakalimot. And so these are the persons who could not really give consent. And deaf mutes who do not know how to read and to write. Contracts entered into during lucid interval, no? But are valid. What is a lucid interval? A lucid interval is at the time na walang insanity yung person. Kasi it could be na yung insanity, it could be permanent or it could be temporary. Ibig sabihin, if it is temporary insanity, at the time na walang insanity, ibig sabihin, pag bilog lang ng buwan, loka-loka. No? Pero pag hindi naman bilog ang buwan, matino naman, and a person entered into a contract of sale, for example, nagbenta ng lupa during a lucid interval, that contract would still be valid. Etong contracts entered into in a state of drunkenness or hypnotic spell are voidable. Ano yung state of drunkenness na nire-refer dito? Ito yung langong-lango na, no? Sa alak. Pag langong-lango, ibig sabihin ay he is not in a normal mental faculty to give yung consent freely. And so therefore, the contract that would be entered into would be voidable. Ganun din yung under hypnotic spell. And of course, yung another, hindi lang na-spell out dito, but another situation would be hindi lang langong-lango sa alak dahil sa kalasingan, even pwede rin na langong-lango even because of drugs. And so they lost yung normal mental faculty. And if somebody is not in his normal mental faculty, it is presumed that they are not in a position to freely give their consent. As to its application sa contract of sale, eto papag-aralan pa pagdating ng contract to sell, pag-aralan pa sa when we learn more on the contract of sale. Kailangang dinagdag ko na lang para for purposes of identifying yung limitations ng capacity, no, to act. Para lang just to emphasize na yung sa provisions dito, Article 1327, it's not exclusive. Yung capacity to act, they could be limited temporarily, or they could be limited absolutely, or they could be limited uncertain situations lang. Like for example, dito where there is a sale of minor or without capacity, but it involves yung the sale of necessaries, no? And these are necessaries for, ibig sabihin it pertains to mga basic uh, basic needs. Um, then he must pay a reasonable price thereof. So, like halimbawa, yung minor bumili ng suka. Under the law, 'pag minor walang capacity to enter into a contract, and so essentially yung ALES sa sari-sari store ay hindi niya puwedeng bentahan yung 17 years old and below. Pero kung bibili naman yan ng suka, ng asukal, 'no, yung mga gano'n, yung bigas, 'no, ah, these are necessaries, and when they are sold to minor or other person without capacity, they are required to pay a reasonable price thereof. Also, strictly yung husband and wife, no, uh, they can, the husband and wife generally can sell their own property, but they are not allowed to sell property to each other, except when there is a separation of property or when there is judicial separation. But when there is a community property regime, ibig sabihin, yung property ni wife, yung property ni husband before and during marriage ay they are deemed to be their conjugal property under a community regime. Uh, they could not sell property with each other because essentially parang they are co-owner. These are considered conjugal property, and so there would be conflicting interest, and there would be a presumption na it is done to prejudice creditors. And so there is a limit as to their capacity to sell with respect to their property when they sell, when the husband and the wife sells with each other. Also, we discuss about age insanity, even penalty, especially for a crime committed. It could also give rise to capacity, to limitation to enter into a contract, or it could limit legal capacity. So this is the civil interdiction that has been mentioned a while ago. Article 34 of the revised penal code, civil interdiction as a form of penalty for those that has been convicted of certain criminal offenses, no, where they shall be deprived during the time of their sentence, during the time that they are serving their sentence, to to manage their own property and to dispose such property or to convey them. So during the time na nandun sa loob ng bilangguan yung preso ay he has no legal capacity, limited ang kanyang legal capacity with respect to the disposal or to the management of his property, and even for the sale of his property. And also, you take note of Article 49(1) that the following persons, no, cannot acquire by purchase even at a public or judicial auction with respect to the guardian, the property of the persons who are under his guardianship, yung sa mga agents naman. Why? Because kung papansinin niyo, executors and administrator of the property of the state, it would give rise to conflict of interest because yung mga guardian, they step in representation the persons who are under their guardianship. Yung mga agents naman, they except in representation for the interest of their principal. The same is true with executors and administrators with respect to the estate and under their administration. And so, by virtue of the law, their capacity to buy, no, is limited, but only with respect to this property. Justices, judges, and other specialists qualified by law. Civil personality is extinguished by death. Upon the death, yung legal capacity of a person would now be terminated, no? Kaya lang, what would give rise upon the death, ang magiging substitute would now be the estate of a person, in which the estate would exist upon the death of the person, but only for the purpose of of settlement of the estate. Ibig sabihin, yung mga ari-arian, as if siya yung it will stand on behalf of the deceased person, but only with respect na for its settlement and for distribution sa mga heirs for purposes of succession. But as to legal capacity, the capacity yung having the force ng kanyang the contracts that they enter into, it would now be through the estate. When the person is dead, maawala na yung kanyang legal capacity to act. However, it would now be the estate that would stand on behalf of the deceased person. And usually this estate, they are represented by executors, as we have discussed, and administrators. But the estate would exist only, the estate of the deceased, only for the purpose of settlement of the estate, yung ari-arian ng namatay. Juridical persons, we also have juridical persons. Kanina we mentioned on the legal capacity of natural persons, yung those who are naturally born, katulad natin. But there exist also juridical persons. And pag sinabi natin yung juridical persons, these persons exist because they are created by law. Hindi pinanganak na parang pinanganak na tao, but they exist na parang tao and they have the rights ng parang tao because they are creations of the law, no? And so juridical persons may acquire and possess property of all kinds as well as incur obligations. Article 44, it provides for a list of juridical persons. They could be the state, political subdivisions, yung mga korporasyon, mga ganon, institutions, entities of public interest, corporation, partnership, associations, no? These are juridical persons. So we have two kinds of persons with legal capacity. First is the natural person, yun yung unang diniscuss natin kanina. And second would be the juridical persons, no? So, yung juridical persons, they have legal capacity or judicial capacity para ding natural person. But they act, but their legal capacity or judicial capacity is exercised by their representatives, especially the board of directors, no? If it is a corporation that is for profit, but if it is not for non-profit, then it would be the board of trustees. Yan. Contract of partnership, or two or more bind themselves to contribute money, property, or industry. No, this is Article 1767 under the Civil Code. No, and the partnership has a juridical personality because